Hello, my name's Nigel Jones. I'm one of the directors of the Practice Plan group of companies, and it's my great pleasure to welcome you to the In the Loupe podcast series. This is a series of podcasts where I get to explore different perspectives on the world of dentistry, covering all aspects of the business of running a dental practice, and I get to do that in the company of some of the most interesting people in dentistry, so I'm very pleased you're able to join me. Welcome to today's episode, where we're going to be exploring the potentially contentious subject of employment law and how that might impact on dental practices. There's been some changes in April, some future changes coming up. Absolutely delighted to be exploring that topic in the company of Sarah Buxton. Hi, Sarah.
Hi, thank you for having me.
Well, I'm delighted that you're able to go up time for this, especially with your level of expertise of both dentistry and also employment law. So. I mentioned about changes in April. That's probably a good place for us to start. So what happened then?
Well, there's been numerous changes that have happened, and I think dental practices really need to look at their employment contracts and their policies and procedures to ensure that they've incorporated these changes into those documents. The first of these changes is the change to statutory sick pay. So first of all, I would say that in my experience of acting for many dental practices, it's very rare that we now come across contractual sick pay. So whereby the dental practice will pay an enhanced rate over and above the statutory sick rate to somebody who has absence from work. What we're talking about here is a change to that statutory sick pay rate. So before April, we were in a position where I do believe in my role as a business owner and as an employment solicitor that the provision whereby you had to wait 3 days before you received any statutory sick pay did act as a deterrent to prevent people from taking absence from work, because to lose a day's pay, you would really have to think about, am I really unwell to go into work? So those people who maybe they have an outlook whereby, oh, I've got a bit of a sniffle, but actually I'm going to lose a day's pay, so I'll still get myself into work, you would find that you'd still end up with that team member in the workplace. And then on the flip side, you would be not paying those people who would, maybe the ones that had persistent short-term sick leave. So therefore I appreciate it would cost you in terms of reorganising the team, but there wouldn't be a financial penalty for somebody having that amount of sick. And don't get me wrong, I don't think that is the only deterrent. I think you have to have good sickness absence procedures in place. But I do think it helped, and I think as an employer, there's some satisfaction in thinking, well, I've not had to pay them, and I can now manage the sickness absence. But what's happened now is that you do have to pay SSP, so the statutory sick pay rate, from day one. And the reasoning behind it is that this government have done some research, and they've tried to justify their position by saying that they found that most people would take more than 3 days off work, so they'd have an extra day just to get SSP, which plays with my mind a little bit, because actually if they got themselves back to work on day 2, they'd received their full pay and they'd be back in work. So I'm not quite sure that justification works. However, what it does mean, and we've got to appreciate here that the laws are applied to all size businesses, is that there is going to be a financial cost to the dental practice. And you can actually work out that cost, because you could take last year, find out how many days unpaid sick was taken, and you can now put a price on that if you like. And so huge cost to a small business here.
So it sounds like you're describing, if I've grasped it properly, two costs: a direct cost, which is the SSP, and an indirect cost because people have lost the disincentive to come into work.
Absolutely. So what it does mean is that all contracts have to be updated, because probably the contract at the moment refers to 3 waiting days where you didn't have to pay SSP. But also I think it does mean that we have to get better as owners and managers at managing sickness. because yes, there is this direct cost to somebody being off. And I think sometimes with absence, it's easy to bury your head in the sand. Don't want to deal with it. It's a pain. But if we don't deal with it, yep, there's the cost of the business, but also this could snowball into something bigger. For example, disability discrimination. So there's a huge risk here to not dealing with sickness absence in the correct way.
Yeah, it's interesting. I once heard early on in my career that short-term sickness is more of a morale problem than a health problem. So I suppose then, given the shift in the law, actually focusing on morale and making sure your team are comfortable and happy and motivated and all the rest of it becomes even more important.
Oh, absolutely is the case. And I think what's missing is what sometimes what happens in practices is we evolve with technology. So, for example, the contract may say something like, you have to phone in. You have to phone the practice manager and report your sickness absence. And I would always encourage that to be the scenario, because to speak to somebody on the phone, you get so much more information out of them and they're accountable to you. Because we've evolved into this world of WhatsApp, I'm finding that people will message in or send a WhatsApp message because they can hide behind it and they're not held accountable in the same way. So it's almost, let's look at those policies and procedures, because we've got an opportunity here, because we've had the change in the law. So although I can say, yes, it's going to affect practices, and practices, I can see the detriment to practices, but let's look at what we can get out of this. And what we can get from this piece of change in legislation is the opportunity to review what we're doing in practice when it comes to absence. And the first thing I would do is say is no WhatsApping, no messaging. Let's go back to picking up the phone and reporting that absence. That's always stage one. And then, of course, when they do return to work, we need to have really good return to work interviews. And when I say really good, I mean absorbing and try to get as much information from that person by listening to them, finding why they were sick, if they need any support, and if there's anything we can do to help them in the workplace. Really important. And when absence is managed, that person, if they are maybe not on board, or maybe not working in the way that you need them to work when it comes to absence, they will probably deselect and they'll leave, or their absence will increase, they will improve, and get better. So it's really, it's an opportunity for us to look at how we're managing absence in the workplace.
Yeah, I completely agree with you on that. And the point I was making about morale and being the issue, that will be what's picked up in one of those back to work interviews. That if actually, it could be that there's something you can fix in the workplace that actually stops the short-term absences.
Oh, very much so. By having a good conversation with the employee, and when I say good, it's about using open questions to get as much from them as possible, because they may be taking that absence because actually they don't want to work with a particular associate. Because they feel bullied or harassed by them, and then you can resolve that issue. It may be that there's something underlying, so they may be pregnant or they may have a disability, and we will deal with that in a completely different way, but at least we can put the support in place to help them. So it is really important to have those conversations. So even though I can see that having to pay SSP from day one may be a bit of a headache, I can also see that actually let's take this as an opportunity to really look at sickness absence and what we're doing in practice to manage it.
Yeah, makes sense. So what are the other changes that have happened?
In April, they've had some changes to paternity leave. And to be fair, in my opinion, I do think this was long overdue, because for somebody to take paternity leave, they had to be employed for 26 weeks, which doesn't sit right with maternity, whereby the individual can take paternity from day one. So what they've done is they have brought that to a day one right, that you can take paternity leave from day one, rather than having to be employed for 26 weeks. So if you have family-friendly policies, I'd refer to them as, so maternity, adoption, paternity leave, we would look to update that paternity policy now. And you would need to communicate that to the staff as well, because not everybody knows about the change to paternity leave.
Okay, interesting. So, and is anything else in April? Or
Yeah, I think the one that's really been downplayed, and I think it's probably because they haven't got their ducks in a row. Because when I last looked at the website, they were trying to recruit for team members and a CEO actually. But it has been established that we now have a Fair Work agency. And I think the reason behind it is because our legal system, especially in the employment side of things, there's an employment tribunal, is completely jam-packed. And I think HMRC are incredibly busy as well. So neither of those institutions are a quick fix. And what they've done is when I say they, the government have introduced the Fair Work Agency, which is a new body, which has been given enforcement powers. And the powers that they have is to enforce a penalty on you and your business if you are not compliant with some of the employment legislation. They have the power to come into your business and ask for documentation, a little bit like the Inland Revenue. It's a similar situation that they can come in and ask for documents and you have to give these documents. And they can enforce you. They're looking at basically whether you have been compliant with things like holiday pay, national minimum wage, whether you have been paying the correct notice pay. And if they find that you are not compliant, they can fine you. They can take a claim to the employment tribunal on behalf of the employee, even if the employee doesn't want to, and you would have to pay their legal costs. So the key here is to make sure that you are being compliant by having the correct documentation in place. But the big worry for me is in respect of associates, because I think for someone who doesn't understand the dental industry, I think for somebody from a body like the Fair Work Agency to come in and for you as a manager try to explain that your associates are self-employed and not employed, and therefore that's why you've not been paying holiday pay for the last 6 years, I think is going to be a very difficult conversation for you to have.
that's really interesting because yeah, it makes sense that you would be concerned about that.
Yeah.
Because let's face it, when you look at a self-employed associate, they're working in the same premises, using the tools. There's lots of things that would suggest actually they're acting as a worker or employee.
Yes.
So you could see why they would be confused by
Yeah.
that. What would trigger a visit?
Nothing. They can just pick you. They don't have to be. There doesn't have to be a report made. They just have the power to investigate. And like I said, the people that work here are not going to be legally trained in tax or employment legislation. So it's going to be a case of, I think, well, it depends, I suppose, on the fine and what they're trying to do at the time. But what I would say is for an associate who, their take-home pay is high bracket, and to go back 6 years worth of holiday, that is going to be a lot of money, a lot of compensation that they're going to be asking for. So I can see myself getting involved in that to try and justify. And I think the other scenario where practices will get tripped up, because I see this a lot, and it's not because anybody's trying to do anything with any malice. It's just because of a lack of understanding, especially if you don't have HR support, is the recording of the correct type of leave. So, for example, a really common scenario is if you have a team member who phones in because their child is sick, that is time off for dependent leave. Whether it's paid or not is down to you. But I know that many practices will record that as sick leave and they get confused. Another scenario is somebody who's paid national minimum wage. You've got a clause in your employment contract allowing you to deduct a course that they've been on, the cost of the course when they leave. You deduct the cost of the course, and all of a sudden they're no longer paid national minimum wage in that last month because you've taken the cost of the course away. So again, I can see these scenarios whereby practices think they're doing the right thing, but they don't know any better. And I think that's where the Fair Work Agency will come in and penalise practices. So it's really good to make sure that you've got your HR compliance in order.
Yeah, that's such a great point, because actually the intent to do the right thing by your team could be there, but if you actually don't keep on top of which I's to dot and T's to cross, you could trip yourself up.
Absolutely. A big one that I come across, and this is the exact same scenario where the practice thinks they're doing an employee a favour. You have a team member who goes on maternity and you only pay statutory maternity pay. The team member says, well, whilst I'm on maternity leave, I'm going to accrue lots of holiday. Why don't you just pay me my holiday entitlement whilst I'm on maternity leave? And the practice owner goes, that's a really good idea, because actually you won't have to take 2 months off when you return to work. You're getting paid a little bit more whilst you're on maternity leave, so it suits you. They come to this arrangement. But actually, by law, you're only allowed to pay accrued holiday when somebody leaves. So as soon as you pay that holiday entitlement over to somebody on maternity, you're actually ending their maternity leave. And you can get into all sorts of issues with tax and so on. And you can end up having to give that back in terms of when they return to work, give them some more holiday. So it ends up being double the cost. But at the time, you actually think you're doing that employee a favour to help them out, but it's at odds with the legislation.
Yeah, I mean, so many avenues I could go down there in terms of what it means for a small business versus a medium or bigger business, and obviously we're dealing with small businesses at the main, here in dentistry. But staying on top of all of this, and as I say, not accidentally tripping yourself up is a bit of a challenge. So what else has changed or is likely to change?
So moving forward, there's a lot more changes, and it wouldn't surprise me if we have more changes to come. But I think the next one, which people are getting confused about, and probably because of the date we've been given, is the changes to the unfair dismissal legislation. So currently, before an employee can make an unfair dismissal claim, you have to have 2 years continuous service. After 2 years, the employer has to have a fair reason and a fair procedure. Otherwise, you can end up in the tribunal for unfair dismissal. So the first 2 years of employment is relatively low risk to dismiss somebody. Don't get me wrong, there are 74 other claims that an employee can bring in that first 2 years. So I'm not saying it's completely risk-free, but we had an opportunity to assess a team member in terms of attitude and skills, see if they fit in. And if they didn't, we could dismiss without this risk of an unfair dismissal claim. What's happened is, as of the 1st of January 2027, you will be able to claim unfair dismissal after a statutory 6-month probationary period. So actually, we only have 6 months to assess somebody now. And that 6-month period starts in June this year, because the law is applicable to anybody who has 6 months service as of the 1st of January. So again, we need to update contracts.
Yeah, and just to make sure that I've understood that. So say I've employed someone in May.
Yeah.
They don't have a right to go for unfair dismissal the rest of this year. But as soon as we tip over into January, they get a right that they wouldn't have had in May.
Yes.
2 years ago.
Yeah. So we need to update contracts, because everybody has different probationary periods in them, depending on how you've managed that. But also, I think the key to this is being on top of your recruitment, because ultimately what we need to do is make sure that we don't employ people who maybe don't have our mindset, our values, our vision. And because to me, I think the skill element of employing somebody is easy in terms of you can train somebody up, you have a job description, you can manage the level that you expect from them, and if they're not reaching that level, skill is really easy to deal with in terms of whether somebody's capable of doing their job or not. And usually with skill, it may be that we can just get them to work in our way or train them up. Actually, most dismissals are about them not fitting with the team. And that is very hard to assess in a 30-minute interview. So looking at doing everything we can to make sure we get the right team members in terms of an alignment with our vision and our values. And I think practices are not doing enough about trying to put off the people that are not going to fit with the practice from even interviewing. And what I mean by that is making sure your vision's on your website, making sure that when you invite them in, it's on the bottom of your email or whatever it may be, so that you're reiterating all the time the type of person you want in the practice. Because once we get them in, it's much harder to get them out again, because we're going to be always at this risk of a tribunal claim going forward.
Yeah, so that's interesting. So I think people might have adopted a philosophy that was a bit of a kind of try before you buy type thing, because we'll just extend probation.
Yes.
or,
Hugely, yeah.
And now what you're saying is actually, no, you've got to work all this out before day one, really, or from the beginning of next year. Yeah. And so that, yeah, you're right. That's really interesting in terms of what it might mean in terms of assessment centres and all of those sort of attitudinal bits that you would previously have had the luxury of a probation period to assess.
Yeah, absolutely. I think that there's going to be a lot more to a recruitment process going forward. I mean, I don't, this isn't my advice, but there are some people saying, well, let's send them to occupational health before we even employ them, because if there's an underlying issue, we can get to the bottom of it and we can put adjustments in place straight away. And that might help thrash out if somebody is not able to actually perform this role early on. There's issue surrounding. I think the skill, as I keep coming back to, is easy as long as you have a good job description. And I think, again, most practices don't use that document how we're supposed to use it, because that document is so important during the recruitment process and during the employment relationship, because it's a living document that we should be coming back to, adapting, amending all the time. When that team member comes up to you and says, I want a pay rise, let's get that document out and see what additional duties you do to justify the pay rise. And it may be that you amend it and they can justify, or it may be that they're doing nothing more than the minimum job description. So again, tell me why you should be having a pay rise. This is a document that is so important when it comes to skill and capability, but we don't use it enough. And I think the document that's going to become really important when it comes to assessing whether they're going to fit with the culture is that vision and values document. And I think at the moment what's happening is that practices may have a vision, they may have values, and they may have it on the wall in the staff room, but we're not sending the message out there to potential employees, and we need to be, because those are when we'll get the people with the right attitude.
Yeah, so I think what you're saying there is that we need to upfront give people reasons to deselect themselves,
100%.
and then actually narrow it down. That's more efficient. Actually, if you just end up with people that are a good fit, that like the vibe of the practice, that's a much better place to start. What other areas do we need to think about in terms of employment?
I think the big one, which most practices are not prepared for, which they should already have in place because the law is already there, it's just been strengthened, is the law surrounding third-party harassment. So what this means is that as an employer, you're supposed to have done everything that you can to prevent third-party harassment. So when we talk about third parties, it's patients, suppliers, the waiter at the Christmas party. What have you done to prevent the harassment? Now, it's not that you have got to prevent the harassment, because obviously you can't control people, and you need patients to come into your practice, and suppliers and practice plan recs and everybody else, all these people that come in, we need that. But what you've got to be able to do is, if you were ever taken to court, show that you had done everything reasonable and within your power to prevent that from happening. So the starting point is always a good policy, is having the correct policies in place. Then it's the communication with the staff. It's having regular equality and diversity training. There are some practical tips as well in terms of a complaints register. If somebody complains about harassment, you need to ensure it goes on a complaints register so you can spot any patterns. So if you've got that patient who's constantly harassing, you would do something about it. Equality and diversity posters, third-party supplier code of conduct. So you say to people, look, before you come into my practice, here's our code of conduct about how we expect you to act. You can send that to your Christmas party venue. Recording your telephones. So, for example, if you have reception and they're obviously touching base with third parties all the time, the step you've taken to protect them is to have those telephone conversations recorded, so that you can do something about it. And it's that type of thing that we're looking at. It's not about controlling the behaviour. It's about ensuring that you've done what you can to make the team feel as though they can tell you about it, and that you will act in response to it.
Yeah, that makes sense. I mean, I think you can't control the behavior. You can't, you've no idea what an NHS patient coming into a practice that feels entitled to, et cetera, et cetera. You can't control that, but it's how you respond to that and what provision you make for responding to it, I guess. And it's more than just putting up a poster that says we do not tolerate abuse of our staff.
Yeah, that would be the starting point.
Yeah.
I mean, going on from that, it's about bringing it to the team meeting. It's about the one-to-ones that you have, where you have a good conversation. When I talk about good conversation, really it's about you as a manager or employer listening, and then acting from the information that you provided. I think too many times I've heard, go and have a good conversation with them, have a good conversation, and a manager or an employer will go and have that conversation, but what they don't do is know what to do with the information that's been provided to them. So if somebody said to you, I feel really uncomfortable when this patient phones the practice, as a manager, your alarm bell should be going off and thinking, oh, hang on, that this could be third-party harassment here. I need to take this a step further. I need to listen to those telephone calls. I need to put it on the complaints log. I need to discuss it with the patient to see if there's something underlying, because again, how you deal with it might be slightly different. If that person has a disability and that's why they're acting that way, we may deal with that slightly different to somebody who doesn't. So it's really important that, yes, we have the good conversation, but when you have that good conversation, you then act on the information that you're provided.
And what's occurring to me listening to you, Sarah, is that there will be people, I've heard it variously described, but let's say who have practices who have heart syncopations. When they see you and they're coming in, they're thinking, oh no, because they're always been difficult. And they've tolerated it for year after year after year after year. So they've almost normalised the behaviour. But now the law has changed, so you can't just say, oh, well, it's Mr. So-and-so and he's always like that. You've got to think quite carefully about.
Yes, absolutely. That is the case now. Yeah. I mean, you've got to think, this piece of legislation came out of the Me Too campaign, which I don't know if you remember, it's going back a few years now, but what happened is, I think one actress that said that she had been sexually harassed, and then all of a sudden lots of celebrities followed because they felt comfortable coming forward, but they'd never come forward and said anything if that one actress hadn't started this campaign. And the idea is, make your team feel so comfortable that they will come forward and discuss this with you. And you're now under an obligation legally to ensure that that happens. And the practices that will have to pay the compensation and will get tripped up are the ones that do nothing. the ones that put no policies in place, the ones that have no training, the ones that don't have a complaints log, because the expectation is a good employer will have all these in place. It's like with all these changes, you will be fined at the tribunal if you have not updated your contract and policies and procedures in line with the current legislation, because a good employer, a reasonable employer, would ensure that these foundations are up to date. So it's about keep moving with the law and make sure that you have the correct documentation in place, and documentation that's living. I think that's really important, because too many times, yes, we've got the contract up to date, but we put it in a drawer, a policy which we never discuss. That's not enough. It's about ensuring that the team are aboard with those policies and procedures as well.
Yeah, makes loads of sense. And, the goalposts are moving all the time. So, and a recurring theme between some of your observations seems to have been the huge importance of deep listening to your team, whether it's deep listening before you recruit them, whether it's after they come back from sick leave, whether it's when they've got a concern about a patient or a supplier or somebody. You've got to really, really listen to your team.
Oh, definitely that is the case. And I think we've got an opportunity here where if you're not the kind of practice where you're keeping up to date, or you're not listening to your team, I think we can draw a line under it and think, right, we've got to change our contracts. And most team members get spooked. They think, oh, why are you changing my contract? Why are you changing that policy and procedure? But actually, we've got the law here saying, right, we have to bring this up to date. So I'm doing what all reasonable employers should be doing across the country. I'm going to make sure that they're up to date. And actually, we're going to discuss these now on a regular basis going forward. So we've got an opportunity to change how we manage the team. Reintroducing that vision, reintroducing the values. And I think by doing this, I think we will end up in a position where the team, we're fostering a culture where the team will work better together and they'll be happier, and you'll just end up be more profitable because of that at the end of the day. So I'd like to say, let's see all these changes as an opportunity to reset how we manage our businesses, because I do appreciate that this, it can seem very negative, and I hear people go, oh, it's always on the employee's side. Or they're always supporting the employee. What about me? Well, let's look at what about you? How can we make this work for you? And I think this would be the way forward. Let's use the documents as a way to look at how we can manage the team better going forward.
Yeah, I love that. That sounds like a perfect place to end the conversation. But it's really good to get up to date on everything with you, Sarah. And I think that way of turning something that on the face of it looks a disadvantage to an advantage, and kind of normalising contractual changes, because you say, I think the danger is you store them all up and then go, oh, we haven't reviewed contracts for 2 or 3 years, we'll do this massive change, and therefore it becomes quite dramatic to the team. Whereas
absolutely.
What you're saying is like constant incremental change.
Yeah, definitely. Yeah.
So before we finish, is there anything else that we need to keep an eye on, or is it just it's going to change, so you stay up to date?
I mean, what I would say is it's my full-time job to keep up to date with the legislation. So I appreciate it's HR and employment law is one of the plates that a busy practice owner has to spin. And there are going to be more changes. I mean, as the government evolves, we don't know what's going to happen. There's consultations, for example, going through about self-employed status and whether self-employed and employee and how that's going to work. So, it's hard keeping up to date with the legislation if it's not your full-time job. So, it's my job to do that. And I'm glad that we've had the opportunity to do this podcast, because it does make people aware of the changes that are happening. But I would say it would not surprise me if we sit here in 6 months and there's a lot more on the cards to come.
Yeah, it wouldn't surprise me either. I mean, you and I have recorded podcasts like this loads of times over the years, and we never run out of things to talk about, it seems. So look, thank you so much, because I completely agree with you. It's so important for practice to be able to stay up to date with this sort of thing, and it isn't their first priority, and hopefully we raise their awareness and they can take action on it. So thank you so much, Sarah. I really enjoyed the conversation.